Hi, everyone. So this is Ilyce, Shugall, and Amelia McGowan. We are back to respond to the unanswered questions from the Mechanics of Immigration Court Part 2. So I am going to dive in. The first set of questions relate to background checks and police reports. The first question is, how can you challenge the contents of police reports? I talked about that in the substance of the presentation. The primary basis that you're going to challenge a police report on is unlawful hearsay. And the key is if your client is testifying inconsistent with the information in the police report, the government's going to try and use that information to impeach your client. But your response is, well, my client's in court, available for cross-examination. My client's testimony is not hearsay. Everything in the police report is hearsay. The police officer isn't here to be cross-examined. The statements made by the accuser's not here to be cross-examined. Therefore, my client's testimony should be afforded greater weight than the police report. So that's really the primary basis to challenge the police report. The other key thing that I raised in the presentation is that police reports are not objective documents. They are advocacy tools that the DAs use to prosecute someone. And so it's also important to point that out, because oftentimes immigration judges sort of think of police reports as gold and they're perfect and they're objective, but that's absolutely not true. And I would say in the last year or so, there's more and more articles out there about the level of bias within the police departments. And I think if you're really fighting bad police reports in a case, it might be worth submitting some of those articles that flag how biased police officers are, particularly against people of color, assuming your client is a person of color. The next question is, if you have someone who's lived in many states, can we rely on the FBI background check, or do we need to do each state? I would say it depends. If the FBI background check shows hits from multiple states, then that might be sufficient. It'd be good to follow up with the courts in multiple states to get court documents. If you have no hits on an FBI background check and you have reason to believe that your client may have had issues in other states, then yes, it's certainly a good idea to do background checks in every state. If you don't have any reason to believe your client has had issues in multiple states, generally the FBI background check can be sufficient. Next question is, would it be a good strategy to not submit any criminal background records to wait and see if DHS will present these for the record and to preserve the objection in court? I would say generally that is a bad strategy. Generally, you want to be the one to present the adverse information about your client, particularly with respect to criminal arrests and convictions. You don't want it coming out for the first time on cross-examination. It looks like your client's hiding things, and that is not a good strategy. There might be limited scenarios where it's better to wait and see, but generally, if you've been able to get the documents about some adverse arrest or conviction record, then the government has them as well. And you should assume that they'll be prepared to submit them if you don't. And then the final question in this section is, how do you handle Interpol red notices, especially when they're listed on the, I assume that's I-213. So it sort of depends on the context where it's coming up. Usually it comes up in discretionary determinations and a danger determination in a bond hearing, or in trying to prove that someone has a serious non-political crime that would bar them from asylum. And, you know, again, it's not a conviction, it's not even an arrest, it's not even a real warrant. It's just something out there that suggests that your client might be wanted in another country. There is one bad case that recently came out. Now I'm forgetting, I think it was a Ninth Circuit case about Interpol red notices and immigration judges being able to consider it in the totality of circumstances. But again, that's a place where if your client's prepared to testify about what happened and what your client believes led to that red notice being issued, you should argue my client's in-court testimony, which is subject to cross-examination, should be given much greater weight than this Interpol red notice that's out there that has no supporting document in the record. If that is the only document that DHS produces to suggest that your client's wanted in another country, that really should not be sufficient to weigh against your client's testimony. Ideally, you have other corroborating testimony that would explain the reason for that red notice. You know, oftentimes we see it like in Salvadoran cases where someone's accused of some sort of gang-related crime. And we know there's tons of country conditions documents out there about the situation in El Salvador and the unfair prosecution of people accused of gang-related offenses, the unfair way certain people in El Salvador are targeted as gang members when they're not. So, you know, it's a very fact-specific scenario, but certainly it's all about weighing the evidence.
All right, thanks, Ilyce. So I'm going to move to another grouping of questions that deal with evidence and authentication. So the first couple of questions are about when should you submit all this evidence? We talked about all the supporting documents, country conditions reports, photographs. You know, when are the best time to submit all these documents? So generally, if you, when you have your hearings, the judge will set a couple of deadlines. The judge will set a deadline for filing applications and also for filing supporting documents. Usually the supporting documents will be much closer to the hearing date. So what I like to do is obviously, you know, send in the application by the time it's required. And I like to take more time getting the supporting documents together, especially if you're working with an expert, especially if you're, you know, preparing your own client's declaration. You know, getting country conditions evidence together can take a very long time. So I use that time. I also like to use this time, you know, I submit it separately because I can get all the evidence together and put it in a organized way for the judge when the judge reviews the case. So I like to use a table of contents. Take a look at the Immigration Court Practice Manual that talks about how to organize your supporting documents, you know, using tabs, making it really easy for the judge to see everything that's there and in a very organized fashion. So I don't like to submit them all together unless there's a very short deadline or it's required. Obviously, first and foremost, follow the deadlines that the judge sets very carefully. But I like to use that extra time to get submitting corroborating documents submitted later. Another question is, does your client's witness statement need to address evidence like photographs that will have been submitted with the 589, or is in-court authentication and testimony the only means necessary and possible to support admission into the record of documents and photos that are not self-authenticating? So authentication in immigration court, I think Ilyce mentioned this, but the federal rules of evidence don't strictly apply to immigration proceedings, but they can be really helpful in terms of guidance. So FRE 901 and 902 deal with authentication. There are also some sections of the CFR that deal with authentication for official records. Take a look at those. Those are really helpful. But there's kind of a broad array of ways to authenticate documents. So, you know, authentication goes to the weight of the document, but one of the ways that the federal rules of evidence suggests is through your testimony. So testimony can be used to authenticate a document. But it's pretty flexible, but it needs to be a means that the judge finds probative and reliable. So I would suggest you going through those, the list of authentication means in the federal rules of evidence. If it's official records, take a look at the CFR provisions. It's 1287.6. Just take a close look at those. But be sure that you do it. Be sure that you do describe, where the piece of evidence came from. But remember that it can come from testimony. It just needs to be probative and reliable. One of the questions also was, what did we mean when we talked about certified translations? The question says, as long as the translator puts his or her accuracy of translation statement, will it be sufficient, or must the translator be licensed? So that comes specifically from the Immigration Court Practice Manual. I think it's Appendix G. Take a look at it. It's got very specific language that you need to include, that the interpreter needs to sign or translator needs to sign. There's a certificate of translation, and I just copy that exactly and put it at the end of the document. The person who's providing translation doesn't need to be licensed, but they do need to be competent to translate between the language that they're translating from in English. There's also a certificate of site translation in the Immigration Court Practice Manual, and that's if you've interpreted something for a client and then read it back to them. So that's something else. If that applies to your client, you can do that as well.
Great. And I'm just going to add one more tidbit on the certificate of interpretation piece. That's a slight tangent, but something that has come up recently over the last few years in the San Francisco Immigration Court, and I'm curious if it's happened with you, where if the attorney of record signed the certificate of interpretation, so the attorney of record reviewed the declaration with the client and then signed the certificate of interpretation, DHS has objected and said that there's a potential conflict and that the attorney cannot sign the certificate of interpretation. Has that happened with you?
Yes, I'm glad you brought that up, Ilyce. That happens here as well. So be very careful about that, be prepared, and have another person review that document with the client first. And they should be the person to sign, because we have seen that happen as well. Thank you for bringing that up.
Yeah. And I would say it happens a lot like in the nonprofit world, because, we don't have a ton of support staff, right? And so you just do it yourself. But it generally isn't an issue with USCIS filings, but it can be in immigration court. All right, so I am moving on to some questions about testimony. And the questions are all about witness testimony. I'm going to read all of the questions because I think I can just answer them all together. So the first question is, what is your advice when DHS asks for diminished weight to a psych expert or declarations who cannot be present for cross, especially now that hearings have been rescheduled several times due to COVID and the expert cannot be available? The next question related, if you plan to submit testimony from witnesses, expert or lay, are you required to put them on the stand for testimony, or can you just submit an affidavit? Could you speak about the considerations you need to think about with respect to oral versus written testimony? And then lastly, given the time pressure on immigration courts, how can we advocate for the IJ to give full weight to affidavits without testimony in court from the witness? A particularly aggressive DHS attorney is likely to push the IJ to give limited weight to witness affidavits if the witness does not also testify. So those all basically are what to do about witnesses and how do you make sure your witnesses are afforded the most evidentiary weight. So in an ideal world, all of your experts who write reports or declarations should be available to testify, even if that means just being available for cross-examination. If your experts are not available to testify, particularly not available for cross-examination, then absolutely DHS is going to ask that their report or evaluation or declaration, whatever it is, be given less evidentiary weight, and the judge has every right to do that. If the expert's evaluation report is corroborated by other evidence in the record, you certainly want to flag that. So if your expert just isn't available anymore or never intended to testify, you can argue that because the expert's written testimony is very consistent with other evidence of record that it should be afforded full evidentiary weight because it's all corroborative. But presumably the judge will give it somewhat less weight than if the expert was available for cross-examination. And that's the same with lay witnesses. Certainly in, any kind of discretionary case, like a non-LPR cancellation case, for example, you might have like 20 letters of support or 20 declarations from friends and family and community members. No one expects that all of those people are going to testify. But what I would suggest is putting on the witness list your top 3 witnesses, perhaps, with the understanding that there's no way you're going to get to all of them. All 3 of them probably aren't going to testify, but keeping that in mind when you do the declarations, make sure that the declarations say everything that you want them to say, because if they're available for cross-examination and the trial attorney in court says, I'll agree to stipulate that the witness would testify consistent with their declaration, we don't need to hear from them, that's only going to work if the person actually is available for cross-examination. So that sort of goes to the last question that I mentioned. There is a lot of time pressure in immigration court. You should be prepared to put on all your witnesses, but in certain cases, especially if the witnesses are going to be duplicative, you're probably not going to put them all on, and you're probably going to be able to do an offer of proof. But if you're thinking about that as you're preparing your evidentiary packet to file before your hearing, just make sure that everything that you want said is in those declarations. And that's particularly true with experts. And I'll say this, like this, for example, just came up in a case of mine where the expert's written report wasn't super detailed on the primary issue we ultimately wanted him to testify about. And that became an issue in part for qualification purposes, but also we had to have him testify extensively because the report just didn't cover everything. That's not ideal. You want the report to be as detailed as possible and cover all the topics that you want the expert to address in case you run out of time.
Thank you. So now I'm going to turn to country conditions. We have a couple of questions about just the quality of reports and kind of how to present those. So the first one is, does it matter from a credibility standpoint if country conditions reports, for example, that the Taliban are taking vengeance on former government security forces that are submitted in support of different asylum applications with the same grounds appear to be virtually identical? For example, that the evidence culled from media reports looks to be cookie cutter. So I don't think that this really goes to credibility because, if they're credible media sources or credible reports, I don't think that as long as, it backs up what your client is saying, it goes to credibility. I think it might go to value, right? Because, or weight, because, they are general country conditions, but I think the more specific you can get, while I think it's really important to have those general country conditions reports, I think the more specific reports you can get tailored to what your client themselves are suffering, I think the better. So if they talk about a particular attack, have reports on that particular attack, things that are sort of tailored to their individual stories. That's where experts can also be really helpful because they can sort of pull out sort of what makes this client unique and sort of how these conditions relate to them specifically. So, I think that judges very much understand. I can't speak for judges, but I at least might agree. But, I think they're very used to getting reports, very similar reports about people from the same country, because they're all fleeing the same circumstances. But I think the more that you can tailor it to individual circumstances, the better. The second question is, are U.S. law student written human rights fact-finding reports about non-U.S. countries generally considered credible? I'm not sure exactly what this is going to. I'm assuming sort of like a memo or something pulling together various human rights reports. I would submit, as the country condition report, the human rights reports themselves. But I also think that it's helpful to have a memo or a brief that's really tying them all together. So, I think this might be what this is going to, but something like that, that's pulling together sort of various sources and talks about why, again, why they apply to this particular client's case, why these reports of these attacks relate to this particular client and why they support a finding of a well-founded fear of persecution, for example. So I think that, might be what that question's going to. But yeah, I think in terms of like organization, it is important to, pull all those reports and articles together and personalize it to your client. But I would always submit the reports themselves.
Yeah, so I'll just chime in on what judges think on country conditions. What I will strongly caution against that frustrated me extensively when I was an immigration judge, and I know frustrated my immigration judge colleagues, was when organizations or certain practitioners would just submit a standard country conditions packet with every case from that country. And so, like, I'll give an example. Like for Guatemala, there was an organization that just had like a 1,000-page packet that covered gender violence, violence against Indigenous people, gang violence. It was all there. And they just submit the whole thing in every case, which was super frustrating because, 75% of the packet was irrelevant to the case at hand. Nothing's going to frustrate a judge more than getting a ton of paper that they're required to look at that's not relevant to the case. So don't do that. All right, so then the next question that I will address is, how valuable do you think it would be to explain or present information on a trauma-informed approach to testimony or evidentiary presentations to the immigration judge? So here's my thought on that. You're either going to have an immigration judge who was like me, who understands trauma-informed approaches to questioning witnesses who were victims of trauma, or you're not. And if you have an immigration judge who is not really educated on trauma-informed approaches or the impact of trauma on someone's testimony, you're not going to be the one to educate that judge. So you can do what you can to prepare your questions on direct examination to take a trauma-informed approach, but you are not going to be able to get the judge to change their behavior or get the trial attorney to change their behavior in the course of questioning your client. Certainly, you can put on psych experts to touch on whatever the manifestation of the trauma is, like if your client has memory issues or your client just completely breaks down and is unresponsive when they get really upset. That's one way to deal with it, but I would certainly caution against trying to tell an immigration judge how to run their courtroom, because that's not going to go over well.
Thanks, Ilyce. That's really good advice. We have a couple of other just sort of general miscellaneous questions. Somebody asked, they haven't had their first master calendar hearing yet, and at what point should they get in touch with OPLA? So in my experience, this really depends on the local OPLA office. They might have sort of their preferred sort of time periods to work on things. For example, here in Mississippi, so our local offices are Memphis and New Orleans. For making PD requests, for example, we touched upon that in our presentation. ICE wants you to get in touch with them and make those requests within 90 days before the hearing. So you might want to get in touch with them and see if they have any deadlines or sort of windows like that that you need to work with. In terms of stipulating, we talked about that as well in our presentation. I think once you've got evidence together to support, whatever you want them to stipulate to, our ICE offices have been pretty open to stipulating to certain facts really at any time. Although we do have a couple of attorneys who also operate within a window like that, like, oh, contact me again 90 days before the hearing. So reach out, kind of get aware of what your local ICE office does, but be aware that some of them may not consider all issues at all times. I think given their caseload, right? So, you might want to try to reach out now and just get, see if you can get more information about those sort of windows of opportunity. Another question is, they said I'm a new attorney. Generally, what steps in order do you take to prepare for an asylum case? Like when you work on declarations and country conditions reports and getting psychological records and work on the brief, et cetera. So this is a really tough question. I think I'm going to give you the lawyer's answer, right? It depends on the person. But what I would say, we talked about all these things you have to get started early, right? Getting records, especially records from other countries, can take a very long time. Working with experts, getting letters from friends can sometimes take a long time. So this is a very dynamic process, and kind of each of the component parts can fuel each other. One thing that's really important to get started with, though, is the client's story. So finding out exactly, what prompted them to come, what pushed them to come, what fears they have about returning, if it's in the case of asylum or related protections. So, a strong client declaration, getting started on that may be a good place to start just to get their story. And that's also important, if you're working with an expert. Often they'll ask to see a client's declaration or something, kind of giving them basis for the claim. But at the same time, the country conditions evidence that you find may give you sort of new avenues for talking to the client and questioning them about. So having a good country conditions knowledge from the beginning is also really helpful. So I hate to say this, but you really need to do all of it at once. You need to get started on all of it at once because it's such a dynamic process. Ilyce, do you have any additions, any thoughts on that?
No, I totally agree with that. I think you might not have to do your full research like on country conditions at the very beginning, but at least, like you said, get a sense of what's going on so you know how to ask questions. And then the other thing that I'll just add to that, being someone who does a lot of mental health cases, one of the things that I also learned along the way in representing Franco Gonzalez class members is if you have a client who does have some significant mental health issues, it can also be helpful to get a psych evaluation early on in the process because it can be really insightful and really help you, not just help the case, but help you to figure out how best to communicate with the client.
That's really great advice. So that concludes our questions. Thank you all so much for joining, and we hope to see you in the next webinar. Thanks.
Thank you.